Hi, everyone. Thank you for taking the time to watch this pre-recorded video update from the official committee of Talc Claimants in the LTL2 case. Today's video is intended to inform you about the latest developments in the LTL Management Chapter 11 bankruptcy. Our primary objective is to unpack the implications of the bankruptcy court's recent decision to dismiss LTL's second bankruptcy filing. My name is Melanie Cyganowski from Otterburg. I am a retired bankruptcy judge, and I am one of the co-counsel representing the committee, along with David Molton from Brown Rudnick and other of our co-counsel. We are joined today by Lee Odell from Beasley Allen, who serves as one of our co-chairs and representatives of one of our members. As a reminder, the Talc Claimants Committee is comprised of 11 members. 10 of those members are either suffering from ovarian cancer or mesothelioma, or they have family members who suffered and died from these diseases. The committee members are up on the screen, and they include Brandy Carl, Patricia Cook, Randy Droren, Christy Doyle as the estate representative of Dan Doyle, April Fair, William Henry as the estate representative of Deborah Henry, Alicia Landrum, Rebecca Love, Sue Summercrest, Tanya Wetzel as the estate representative of Brandon Wetzel, and Blue Cross Blue Shield of Massachusetts. The TCC was appointed by the Office of the U.S. Trustee. The committee is the official committee specially appointed under the Bankruptcy Code and is the fiduciary which represents all Talc claimants. Under the Bankruptcy Code, the committee has a duty to communicate with all of the creditors and claimants in the LTL bankruptcy case. Lastly, let me remind you that we are not your lawyers. We are not here to give you legal advice. As always, we urge you to discuss any questions you may have with your personal counsel. Now let's jump into the update. David?
Thank you, Melanie. We really appreciate all of us, your introductions. On Friday, July 28th, Judge Michael Kaplan of the Bankruptcy Court for the District of New Jersey ruled in favor of the Talc Claimants Committee, the TCC, and a host of other movements in dismissing Johnson & Johnson's subsidiary company, LTL's second bankruptcy filing. We expect that Judge Kaplan will enter the order actually dismissing the bankruptcy case sometime during the week of August 7th, at which time all pending cases in the tort system will be released and are free to be prosecuted. The TCC believes that this is a triumphant victory for the thousands of cancer victims who deserve to pursue justice against Johnson & Johnson in the tort system and who should not be coerced into low-value, non-consensual settlements as part of the bankruptcy plan. The bankruptcy court's ruling validates the TCC's belief that Johnson & Johnson used the Texas two-step legal maneuver in bad faith and manufactured financial distress in its LTL subsidiary. The dismissal of the bankruptcy case means that all pending cases will return to the appropriate judicial forum, the tort forum, and either your case will go to trial, where your case can be heard in front of a jury of your peers, as the Constitution of the United States intended. Or, of course, you can also have the opportunity of settling your case with J&J, as has been done in the past, but without the unfair overhang and duress imposed by an artificially limited pool of resources, which would have been the result of J&J's bankruptcy strategy had that strategy been successful. What this means for existing claimants is that your cases will no longer be held up in the bankruptcy system for what would likely be several years or more, and can now be pursued in their proper forum. Individuals with specific questions about their cases should contact their attorneys to determine the best legal strategy to pursue their claims. Melanie, please continue.
Thank you. And now we would like to discuss the immediate actions being taken this week. On August 2nd, last week, Judge Kaplan issued what is called a memorandum opinion determining that the bankruptcy case must be dismissed. But the case is not actually dismissed until an order dismissing the case is entered on the docket. All parties are now in negotiation about how to address some remaining administrative matters, including whether or not the TCC can remain in place for the purpose of defending an appeal by J&J and the debtor. The final dismissal order ending the bankruptcy case is expected to be entered by the court sometime the week of August 7th. In the proposed order, the TCC also requests that the debtor be prohibited from refiling for at least 6 months. This request is being opposed by the debtor, but Judge Kaplan will determine whether this request by the TCC should be granted. Once the case is dismissed, there are several important items to keep in mind. First, upon dismissal, there will be no plan of reorganization or vote on the plan of reorganization in the bankruptcy case because it will have been dismissed. Second, there is no settlement that is being forced upon non-consenting claimants, again, because the case will be dismissed. Third, deadlines to file lawsuits will once again be triggered, so it is important that you contact your counsel regarding the ability to pursue your own claims against the debtor. If you don't yet have a lawyer, you should reach out to one. David?
Thank you, Melanie. The TCC plans to continue communicating with you as long as the court allows through our website, which is at ltltalccommittee.org. That's ATL, that's LTL, TALCCOMMITTEE.org. And the email address for questions is questions@ltltalccommittee.org. That's questions@ltltalccommittee.org. However, depending on the judge's ruling on the TCC's continued existence, the committee may be disbanded. Should this occur, our website will remain online for a brief period of time following the entry of the dismissal order. As I mentioned, this is certainly a triumphant victory for the TCC, and we believe for all Talc claimants. We remain diligent in the event that J&J takes a new legal strategy. Some possible scenarios include J&J or LTL seeking to stay the effective date of the dismissal order in an effort to keep the present injunctions on prosecution of trials stayed pending the effective date of the dismissal order, or refiling of the bankruptcy case in New Jersey or in a different state, or pursuing other forms of corporate transactions, or reaching a global resolution in the multi-district litigation, the MDL in New Jersey, which was pending since before the first LTL bankruptcy case was filed. The TCC, including our 11 members, their member representatives, and committee counsel are steadfast in our commitment to fight for justice and fair compensation for you, the thousands of individuals and families of those victims who are diagnosed with ovarian cancer or mesothelioma as a result of J&J's talc products. We encourage claimants to consult their legal counsel to determine how to advance their individual cases.
On behalf of members of the TCC and representatives, I just wanted to take a moment to thank Melanie and David and their brilliant legal teams who worked tirelessly in the pursuit of justice for our members and all claimants, ovarian cancer and mesothelioma in this case. Their excellent advocacy resulted in the defeat of J&J's pernicious attack on the tort system. There will never be enough words to express the immense gratitude that we feel, but the value of your work, Melanie, David, so many others, cannot be overstated. Simply put, thank you. We appreciate your work, your diligence, your courage, your persistence, and we're excited to celebrate this moment with you and with all claimants who now can pursue their cases in the tort system where they rightly belong.
Thank you, Lee.
No, thank you, Lee. David and I and all of the co-counsel have been honored, truly honored throughout this process to represent the Talc claimants in their pursuit of justice. And we too are grateful to be here. David and I thank you all for joining us today and for your interest in this case for the last 2 years. We will continue to stay in touch, as David said, as long as we are able to do so. If you have any questions about the case between now and then, please don't hesitate to contact your own lawyer or submit questions to the email on our website or contact any of us. We will endeavor to respond promptly to all of your questions while we are able to do so. Thank you.